How small claims court works in Ontario. We estimate this script will generate a video of approximately 7 to 9 minutes in length. If someone owes you money in Ontario, damages your property, or breaks a contract, you may be able to sue them in small claims court. But the process can feel confusing if you've never dealt with the legal system before. In this video, I'll explain how Ontario Small Claims Court works, step by step, including how to file a claim, what happens before trial, common mistakes people make, and how you actually collect money if you win. Let's start with the basics. Ontario Small Claims Court handles civil disputes involving claims of up to $35,000, not including interest and costs. It's designed to be simpler and faster than higher courts, which makes it more accessible for everyday people and small businesses. Common cases include unpaid loans, damage to property, unpaid invoices, landlord and tenant disputes that fall outside the landlord and tenant board, breach of contract claims, and disagreements over services or purchases. But just because it's called Small Claims Court doesn't mean the process is casual. You still need evidence, proper documents, and organization. The process usually begins when someone believes they're owed money or suffered a financial loss. Before filing a lawsuit, it's often smart to try resolving the issue directly. Many people send a demand letter first. A demand letter explains what happened, how much money is owed, and gives the other side a chance to resolve the dispute before court. If that doesn't work, the next step is filing a plaintiff's claim. You can file online or at a courthouse in Ontario. In the claim, you explain who the parties are, what happened, how much money you're claiming, and what evidence supports your case. There are filing fees, and they can change over time, so it's important to check the Ontario government website for the latest amounts. Once the claim is filed, the defendant must be officially served with the documents. You can't just text them or casually mention the lawsuit. Service has legal rules. Usually the documents are delivered personally, by mail, courier, or through another approved method. After being served, the defendant normally has 20 days to file a defense if they disagree with the claim. If they ignore the lawsuit completely, the plaintiff may be able to request default judgment. That means the court can decide the case without a trial because the defendant failed to respond. But in many cases, the defendant does respond, and the case moves forward. One important stage is the settlement conference.
A settlement conference is a meeting with a judge or deputy judge where both sides discuss the case, explore settlement options, and identify the issues that would matter at trial.
A lot of cases settle at this stage. Why? Because trials take time, cost money, and involve uncertainty. Settlement conferences give both sides a chance to negotiate realistically. If the case doesn't settle, the court may schedule a trial. At trial, both sides present evidence and arguments. This can include documents, receipts, contracts, emails, photos, videos, and witness testimony. The judge listens to both sides and makes a decision based on the evidence and the law. One of the biggest mistakes people make in small claims court is showing up unprepared.
People sometimes assume that because the court is small claims, they can just explain their story casually and automatically win. But evidence matters.
Good organization can make a huge difference. That means bringing copies of documents, organizing timelines, keeping records of communication, and making sure witnesses are available if needed. Another common mistake is suing the wrong person or business. For example, if you sue a corporation, you need the correct legal business name. If you sue the wrong entity, your case can be delayed or dismissed. It's also important to understand that winning a judgment does not automatically mean you get paid immediately. This surprises many people. If the defendant refuses to pay voluntarily, you may need to take additional enforcement steps. That can include garnishing wages, freezing bank accounts, or placing a writ against property. Enforcement procedures can involve additional paperwork, fees, and time. Another thing people should know is that there are limitation periods. In Ontario, many claims generally need to be started within 2 years from the date the problem was discovered. Waiting too long could mean losing the right to sue entirely. Now let's talk about legal representation. In Ontario Small Claims Court, many people represent themselves, but you can also hire a lawyer or paralegal. Because the rules are simpler than higher courts, paralegals commonly handle small claims court matters. Whether or not you hire representation often depends on the amount of money involved, the complexity of the case, and your comfort level with legal procedures. If you're representing yourself, preparation is critical. Read the court rules carefully, keep your documents organized, stay professional in all communication, and focus on evidence instead of emotion. The judge cares most about what can actually be proven. It's also important to remember that court should usually be a last resort. Lawsuits take time and energy. In some situations, negotiation or mediation may resolve the problem faster and more cheaply. But when disputes can't be resolved, small claims court gives people a structured legal process to seek compensation and accountability. To summarize, the Ontario Small Claims Court process generally looks like this. First, try resolving the dispute directly. Second, file a plaintiff's claim. Third, properly serve the defendant. Fourth, wait for a defense. Fifth, attend a settlement conference. Sixth, proceed to trial if necessary. And finally, enforce the judgment if payment is not made voluntarily. Understanding the process ahead of time can help reduce stress and improve your chances of presenting a strong case. And remember, court procedures and fees can change, so always check official Ontario court resources or seek legal advice for your specific situation. Settings: use appropriate media.